Good morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Law TV. Before I begin, if you haven't already, please go ahead and hit that subscription button, the like button, and make sure y'all turn that notification bell on when y'all hit that subscription button. I'll give y'all a second to do that. All right, so let's just jump right into this. This is an ebook that was sent to me from someone who knows what the fuck they are doing. I haven't read it all yet. I just read bits and pieces. But what I'm going to do is I'm just going to start over. Also, I was told by the author of the book that I can now make this public. So that's why it's going on the YouTube channel. And I was also told that if you requested a copy of this, that I could send it to you. The author has given me permission to do that. So if you want a copy of it, just let me know. Give me your emails, and I'll send it to you whenever I can. So I'm gonna jump right into this. Just to let y'all know, I didn't even know this, y'all. I didn't know this at all. But the author did some extensive research, it seems, and they found this and they wanted me to give it to everybody. So I'm gonna go ahead and start. Hidden obscurity within the family law industry, exposed, and the holy grail of defenses hidden for over a century. Now, this book obviously is 68 pages, and I'm not going to read all of it. I think I'm just going to do, a series, or so to speak, on it. And I guess I'll just read everything from scratch until until the book is actually complete. Let's make this a little bigger. Dear American public, the contents of this book are about to expose to its readers 100 years of obscurity hidden across these several states within the family court industry, involving and removing the parental power from parents in order to execute a reciprocal pecuniary scheme to extract funds to fund what is most certainly a legal child trafficking ring. The ears may be so desensitized to the notion that our American family courts have legally constructed an industry to remove parents from their children for the purposes of financial gain. However, this book will strike another accord that shall touch and shock the minds of parents and non-parents across these several states. This book will show you through case law and statute and author explanation the obscurity that has been kept from parents involved in contested family court cases, CPS, and all other similar family areas. Let's go down. The purpose of this book is not only to show how to protect your parental power that has been hidden for nearly a century, but prove the above with case law and show how these family court erected industries are currently legally trafficking children at the financial, emotional, mental, and spiritual expense of families. I propose a question to the reader. What if your state legislature, judges, attorney generals, and most of the bar association have all acted in concert, that means together, uh, in concert, by, through, and deliberate cases strategically placed in the judiciary, notwithstanding the deliberate obscured verbiage in state statutes? to ensure the reciprocal monetary gain through incentivized alienation, and to ensure that parents would never find these defenses, and even if they did, relief could be foreclosed. This is what you're about to witness with your own eyes. On that note, America should familiarize themselves with John Locke's treatise on the state of nature and how your consenting to be governed arises from a reciprocal compact accorded by your state constitutions for your state to provide protection to person and property, as I fear that to assert these holy grail of defenses to save your own children will make you an enemy of a tyrannical trafficking state and breach that contract. I think I know what they're saying. This book is written in a chronological order, explaining the holy grail of information, the obscurity in plain sight, the strategically hidden remedy by your state legislature, and the 100-year-old case law that will operate in your favor that derives from the law of nature. This booklet includes templates for, as I see it, as in aerial assault of defenses to save the seed, excuse me, defenses to save the seed corn of the nation from legal child trafficking. This fight is solely about restricting the states from utilizing our children, the seed corn of this nation, as a means of monetary gain through the unlawful, unjust, and unnecessary removal of children from the parental care of the parents, removing their parental power without just cause. This battle is a battle we must win. What is the holy grail of defenses that the family court mafia wishes to keep hidden from statute and case law? The answer is parental power. Unbeknownst to the American public, parental power is a property right. let me rephrase that. Unbeknownst to the American public, parental power involves property rights that the state cannot take away from the individual without just cause. If the state were to do so, it would violate a sacred zone of privacy rights that would upend the law of nature, which precedes the Constitution. Unbeknownst to millions of parents in America that were or currently involved in custody proceedings, CPS, DFCAS, I'm not even sure what that means, and juvenile proceedings, any removal of your children from your custody stripped you of property rights, parental power. This means if you have been adjudicated a non-custodial parent and are court-ordered a mere visitor with visitation privileges, he's right about that. Whoever they are out there, they're right about that. He or she or whatever, visitation privileges, your property rights have been removed secretly. They are absolutely right about that, just to let y'all know. What the courts have hidden, however, is if these rights are removed without a finding of fault at the outset, that such removal is warranted due to detrimental acts of the child, then you may be entitled to equitable relief from the custody, from your custody order, including any support orders based on numerous of case laws that recognizes these rights deriving from the law of nature, meaning regardless of the case law or the state of the cases or the state of the case, these rights exist and deserve protection. Moreover, for any parents dealing with CPS, parental power applies to you, which means that not only is your custody deserving of heightened protection due to third-party custody disputes, but your property rights are as well. They seem to be right with what they're saying, y'all. Before I start reading this is let me go ahead and just say this right now. If you are a man or a woman and you are not taking care of your responsibilities as a parent, this video is not for you. You need to take care of your responsibilities as a parent. Take care of your fucking kids. This is no. I'm not making this video to help you get out of paying child support if you are a terrible parent and you just don't want to take care of your kids. That's not this. You just click off the video right now. This remedy is not for you. Your ass deserve to pay child support. This video is not for you. Now, on the other hand, if you are a man or a woman and you take care of your kids, but the state somehow got involved through maybe lies or somebody, yeah, basically lies. Somebody made false allegations on you with the Department of Human Resources, something like that, or CPS, so on and so forth. And you're trying to fight this. You're trying to get your remedy. You want these people to leave you alone so you can continue taking care of your kids and exercising your parental power and parental discretion how you see fit in regards to your children. This video is for you. I'm gonna go ahead and jump back into this, y'all. To explain this quickly to the reader, I want to give an example of what parental power is through case law, hence the holy grail of defenses, and what has been hidden. Keep close memory of all color codes. Author. Here, the case law is providing proof that one, parents are entitled to their child's services and proceeds of their labor. This property right exists in modern day statute as well. Give me 1 second. I got to turn that alarm off, y'all. Sorry about that. I'm going to pick up where we left off. This property right exists in modern day statute as well. I'll explain this soon, what services and proceeds of a child's labor means soon, but for now, we must know what parental power is. Second, the case law is also stating that this right to services and proceeds to a child's labor is indeed a property right. The child shall be under the control of the parents, who are entitled to his services and the proceeds of his labor. This is 1983. This is looks like a Georgia case. Yeah, it is. It's a Georgia case. Damage sustained by the father for loss of services of minor child is damage to a property right, and action for damages thus arising may be brought within 4 years. This is in 1928, so they've been known about this stuff. Yeah, they've been new about this stuff, y'all. That's another Georgia case, just to let y'all know. Author. Here, the case law is showing that unless parental power is lost or relinquished, a parent is entitled to this property right. In other words, when this parental power is lost, a parent is not entitled to the value of the services and labor of their minor child, a property right. Unless parental power has been lost or relinquished, a parent is entitled to the value of services of the minor child, whether contract for services is made by a parent or the minor, and even payments made by an employer to a minor for necessaries. That's a legal term too, necessaries. And that is another Georgia case. There's a footnote here. I'm going to read this footnote. Many state statutes support this. For instance, read this Georgia statute here. In the event that a court has awarded custody of the child to one parent, only the parent who has custody of the child is entitled to the child's services and the proceeds of the child's labor. So they violated a natural right via statute. And that's what it appears that they did with that statute. Parental power, something like that. That's what it seems like they did. I'm not really sure how to word it right now, but they did something like that. This case reference is showing how this property right, parental power, may be lost. One, by contract, releasing right to a third person. Consider the parents who sign consent decrees in CPS cases to give their child to the custody of the state and follow a case plan for their child's return. Did CPS have any right to such before your consent? Much more to follow. 2. By consenting to adoption, and a parent could consent to adoption to lose parental power. 3. By failure to provide necessaries. I've heard Yusuf L. He gave he read the definition for necessaries from a law dictionary. I've heard him do that a couple times actually. Consider the parent who has lost custody without being proved to have failed to provide necessaries or abandonment. Read the important note to the right. Until majority, a father is entitled to the services of his child and the proceeds of his labor, and that his parental power is lost by 1. Voluntary contract releasing the right to a third person. 2. By consenting to the adoption of the child by a third person. 3. By failure of the father to provide necessaries for his child or his abandonment. Important note, found in Georgia statute, there are also hidden more ways to lose parental power. By consent to the child receiving his own proceeds, which shall be revocable at any time. By consent to marriage of the child, by cruel treatment. Okay. Here, the Georgia Supreme Court is touching on these property rights that derive from the state of nature. They are stating that in a custody proceeding or any other involving the removal of a child, the one deprived of custody is deprived of the right to his or her child's services, which means that one without custody, the non-custodial parent, or any parent without custody is deprived of a property right. Keep this red color in mind. However, this should ring bells in the mind of the reader. How can one be deprived of a property right without fault on his part? Meaning, as shown above, 1. Releasing the right to a third person. 2. Adoption. Or 3. Failure to provide necessaries or maintenance and abandonment. 4. Consent to the child receiving his own proceeds. Or 5. Cruel treatment. I'll soon show how maintenance is separate from child support below, and how child support shall not even be established until it is first shown that a parent failed to provide maintenance while the child was in his custody. Let's go and read this case law and see what it says. There can be no doubt but that the awarding of the custody of the child to the plaintiff in the decree of divorce deprived the defendant of his right to her services. He could not command her services while the plaintiff was entitled to her custody. What is that? Looks like that's an Indiana case from 1879. So they've been knew this stuff, y'all. They've known this stuff for a long time. But this is a case from 1879, Supreme Court of India. And whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. There's your remedy right there, y'all. I think that's what he's getting at right there. There is the remedy. I'm going to read this again. This is in 1927. What is this? Looks like another Georgia Supreme Court case. That's what it looked like. But there's your remedy right there, y'all. I'm going to read it again. Whatever deprives the parent of the right to the custody and services of the child without fault on his part, that means without any basically lawful purpose or without any justification, that's what they mean, relieves him from the duty to support the child. That is equity. That's what they're doing. That's equity. They're saying that you deprive this parent of a property right without any justification. And since you have done that, you relieve him from the duty to support the child. There's your remedy right there. There's your remedy. Now, a lot of people, especially parents who actually love and want to be in their kids' lives, they're going to fight to be in their kids' lives. They're going to use every resource that they have. They're going to go to the law library themselves. They're going to start studying this shit from themselves. I know because I would do the same thing if I was in there. In there, I would do the exact same thing. But there's your remedy right there, y'all. Sorry about that. Had to get me something to drink. Give me 1 second, y'all. All right, let's get back to it. Author. Reading this case law will show why this parental power, property right to the services and labor of your child is the holy grail of all defenses that has been hidden for over a century. What this case law is stating is that if this right that derives from the law of nature is deprived without fault, meaning the parent did not do any of the five things stated above, he's right. Whoever the author is, she here is right. As I found in supporting case law, then that parent is relieved from the obligation of child support. There's your remedy. A question arises in two contexts. First, why are parents in contested family court cases not involving a third party being stripped of parental power, property rights, to the value and services of their child's labor, without the court adjudicating whether there was any fault on a parent's part to lose such parental power? And they will do shit like that, y'all. They will do it. It's like they won't expressly do it. They'll implicitly do it, meaning it's implied from the way the so-called court adjudicated the case. They do shit like that, y'all. They will do shit like that. They'll do it and won't even tell you why. You won't see it nowhere mentioned in the damn paperwork. They do shit like that. What I have found in what I have found in my studies is that the states have neglected to even mention this, let alone require it by statute before removing custody of a child, and have done so in order to avoid, let's go down a little bit more, to avoid adjudicating it to provide broad leeway and ease access to strip such parental power from parents for monetary gain. Let me go back up. This is what they I think this is what he mean by your argument could be foreclosed. So basically, what is a foreclosed argument? A foreclosed argument is an argument that you did not raise in the trial court. You have waived that argument. It's foreclosed. You can't bring it up in the appellate court because you should have brought it up in the trial court, but you didn't. You didn't. That's what it sounds like to me. So that's why they're making this stuff so obscure, so you don't know about it. Because if you knew about it, you would raise this argument in the trial court. And if I'm not mistaken, pursuant to what is it? Was it Title 4D or something like that? I think it's in the Social Security Act or something like that. Anyway, since they're not ordering you to pay child support, I don't think that the state, the corporation called the state, would get any financial benefit from it. That's what it sounds like. I could be wrong, but that's what it sounds like. The right to the services of the child and the obligation to maintain them together, whatever deprives the parent of the right to the custody and services of the child without fault on his part, relieves him from the duty to support the child. This is 1927. That is another Georgia case. That's why I keep telling y'all, y'all need to go and read old cases. Every now and then you might see something that sticks out to you and you want to write it down. Maybe in a modern case, maybe from the early, maybe 50s, 60s, 70s, 90s, something like that, or maybe in the 2000s. You may see something like that. But the old cases, they're good cases. They're very good cases. That's why you need to read old cases. The right to the custody and the earnings of his minor children are reciprocal, and whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. This is your remedy. That is your remedy. Let's see. I think I left off about right here. Continued. Okay. As you can see, again, without fault on part of the parent who has been deprived of custody relieves the parent from the obligation of support. Let's see. This supports the theory that if a woman who initially is entitled to custody as a result of birthing a child has kept a child away from a man, he was thus not entitled to support the child, not to support some petty grievance. Let me see. Hold on. Not to support some petty grievance, but only because it indeed. What is it? Oh, but I think my eyes might be getting bad, y'all. Sorry about that. Uh, but only because it is indeed the duty of a father to provide for a child he has brought into this world. But it is financially implausible in law and in nature to require a man to support a child if the mother is actively secreting the child away from the father. How many men can you imagine are currently on child support who, at the time of the petitioning for their child, the mother refused to allow the father to see nor spend time with his offspring? This injustice has been ignored and hidden in order to continue the extraction of funds from the unaware father, unlearned in law, and monetize spiteful behavior, which is now a billion-dollar industry, which has waved the hand at these case laws. Let's see. When a man abandons his child and casts it upon the public, he becomes liable for its support. But it is entirely impossible to treat a child as thus cast upon the public when the fact simply is that the mother has deserted the father and carried away the child and continues to support it. I see. So that's equity, and that's an Indiana case. Y'all see how old this case is? So this means that this shit has been going on for a long time, y'all. This is from 1889, y'all. That's over 100 years. This shit been going on, and they been knew about this shit, man. Um, Give me 1 second, y'all. I'll be right back. One more second. All right, y'all. I'm gonna go ahead and continue. What is the right to the services and labor of one's child? Part one. It is the biggest kept secret in America. Just to let y'all know, I've never heard of that. Well, I take that back. I did hear something very similar to that. And I think it was a Roman principle or something like that. I can't really remember, but I do recall hearing something like that. But I just never really dug deeper into it, to do some research on it. It is the biggest kept secret in America. This is a right long antecedent before the Constitution arrived. Now, this is not to be confused with with the notion that children are property, although it is my contention that children are property, and I'll tell you why. It's not your semen, your property. It's not the hair on your body, your property. It's not your skin, your organs, your saliva, your urine. It's not that your property. Your children are your property. How the fuck is your semen your property, but your children are not your property? When your children are basically your semen. It's not a woman's egg her property, or not her organs her property, her spit, her saliva, her urine, her hair. Is that not her property? I don't mean to be argumentative. I'm just stating the obvious. I think I know why the author is saying what they're saying though. uh, Back to what I was reading. What am I stating to the reader? What I am stating to the reader is that according to our common law and the history of the English times, from which our common law follows, fathers had a property right in the services and proceeds of their children, not their child. Hold on, whatever. There's a property right in the services and proceeds of their child, not their child. Ah, I see what he's saying. Today, the right to the services and proceeds of a child's labor is still recognized. However, because of equal protection concerns, both parents are now entitled to this property right. I see. I can imagine the opposition of freedom who have an incentive to keep children enslaved to find the notion that parents even stating that they have rights to the services and proceeds of their child labor is absurd. Yeah, I can see that too. Some may argue, especially opposing attorneys, that no child can be expected to work for their parents at such a young age, let alone have all of their wages go to their father or mother. I don't see why not. You're supposed to take care of the family. You're supposed to take care of the family until you reach the age of majority, and then you go out and you start your own family. Keep in mind to remember all the color codes as they are color coded the same for a reason. However, this is only a trap, as the loudest knows full well that this has nothing to do with so-called servitude of a child and can be proven by tracing this right all the way back to the days of old. According to common law, fathers owned land and were essentially the king of their household. Their children were essentially their heirs to their throne, or as we call it now, the estate. True. That makes sense. As such, fathers required their children's services for the upkeep of the family's castle, farm, or land, which all belonged to the fathers, or family estate, for which he would pass down to his child. Now, of course, times have changed, and no major number of fathers own castles or very large farms, let alone utilize the verbiage of heir to the throne or estate in today's time. I think I'm gonna make these in. I'm gonna try to keep it around 30 minutes, maybe a little over 30 minutes per video. Um, because I don't want to make this too long for y'all. However, although the size of the father's real estate might have decreased and verbiage changed, including the required services, excuse me, this property right remains. Parents may use their child services for accounting for their family business, to work for the family business, as many different cultures of Middle Eastern and Chinese do, to run errands for the business, to plant vegetables in the backyard, all the way down to cutting grass to keep the property taxes stable, to simply taking the trash out and washing the dishes. This is the property right to the services and labor of one's child, which derive from the law of nature. No state can give nor take these rights without just cause. However, parents are not only entitled to the services to their child's services only if that parent is providing maintenance. Okay, I see what he's saying. He says, however, parents are only entitled to their child's services only if that parent is providing maintenance for the child, which includes the basic necessities of life. If a parent fails to do so or abandon his or her child, consent to the child receiving the proceeds of his or her own labor, or commit a cruel act, then and only then it becomes a fault on that parent's part, causing such parent to lose parental power, the property right to the property right to the value and services of his child's labor, which then and only then gives the state the right to remove such property right and deal with the parties before them as they let me see and deal with the parties before them as they see fit. I think this is the last page I'm gonna read. Fathers also have the right for their child to bear his last name, heir of the estate. For this reason, we all know the modern names today: John Henry I, John Henry II, John Henry III, John Henry IV. I see. If this has not changed in the equal protection spectrum, then essentially this is an argument to be made about what else should have not changed. Ask an attorney to do Ask an attorney to do so, then eventually he or she will find this and decide against such lawsuit. Moreover, with the legal skill I have obtained, I believe there is an argument to be made that a mother can be stopped from having an abortion by declaratory and injunctive relief of the father asserting claims that because the woman has consented to having a child or sex, she should be stopped from aborting the child because the father has a right to the continuation of his bloodline, heir to the estate, and we know there is no constitutional right to abortion. So, as you have read, y'all know that, right? I'm gonna talk about that, for a second. I'm gonna stop right here. Um, they overruled Roe v. Wade and said you don't have a constitutional right to abortion. Um, I don't like when these so-called justices, they say that there's a living, breathing constitution. I'm gonna tell y'all why I don't like that. Because that allows them to amend the Constitution without amending the Constitution. In other words, they don't go through the proper channels that they need to, meaning they don't solicit the authority of the sovereign, which is the people, to change their Constitution. They just do it. It's not an express amendment; it's an implicit amendment by what they're doing. They're saying, well, times have changed, so we think the Constitution means this. No, motherfucker. That is not how you do that. That's a violation of due process, actually, if you ask me. Now, I'm not saying that I have any say so over what a woman does with her body. I personally do not support abortions. However, that is not my body, and that is not my kid. So I really shouldn't say any damn thing. I think the only one who should say anything in regards to an abortion is the actual father of the child. But then you also have to take into account potential fatal um, health factors that women endure as a result of them becoming pregnant. So I take heed to all of that. But I'm gonna end that conversation right about there, and just get back to what we was talking about. So, as you have read and will continue to read, this property right has nothing to do with forcing a child to perform labor. It has everything to do with simply being entitled and having such a property right to the services and proceeds of a child's labor only because this is in return for the support of the child, and whatever deprives Your custody of such child without fault on your part relieves parents from the obligation of support. Let's see. Let me close this out. Now that you have identified that a property right in parental power exists and what it is, let's refresh your memory and continue swiftly. As you have read above, the Georgia Supreme Court stated, trust we will get to the meaning of the consent to the child receiving services, receiving proceeds of your child. Let me see, receiving proceeds of your labor soon. I'm sorry, y'all. Whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. And that is an Indiana Supreme Court case. Let's go right here. In essence, the argument is simple. What right would a state or state agency have to deprive a parent of their child without proving that parental power property rights has been lost without fault on their part, including forcing a parent to pay support without having custody of his child due to no fault of his own, after all of what we have just read. I think I'm gonna read this last page right here. Let me see. Yeah, I'm gonna read this last page right here because this really shocked me when I was reading this. This is what he's talking about. Whoever it is. This is where the author is talking. I don't know why I keep saying he, but this is where the author is talking about the obscurity, how they made this shit obscure, and it's vague, and it's not really clear as to what they're talking about. So I think I'm gonna read this right here. The opposition's scheme to foreclose relief and the remedy. Let's see how far are we long? About 42 minutes. I might as well just do a damn hour. uh, imagine a parent's argument in court. Due to the court order granting visitation, which is privileges, to the parent and depriving the parent of the property rights at no fault of my own, I have been deprived of the right to the custody and to the services of my child property rights, and thereby relieved from the duty of support as the law of nature deems in my being deprived of services due to no fault of my own. Imagine the parent seeing his child 96 hours a month and paying thousands in support, knowing full well it is unjust according to law, but the parent is now foreclosed of his or her relief or relief being harder to obtain due to the fact that a court or bar attorney now alleges in full assault to protect its trafficking scheme that this claim to terminate a support order and go back to your original status before the order granting custody is barred by res judicata and estoppel. Res judicata. This is what she or he is about to say. What she's about to say. They're about to give you the definition of res judicata, the common law definition of res judicata in 1876. And then they're going to give you another definition of res judicata in 1980. And you'll notice how different the definitions are. Res judicata. It is finality as to the claim or demand in controversy, concluding parties and those in privity with concluding parties and those in privity with them, not only as to every matter afforded and received to sustain or defeat the claim or demand, but as and to any other admissible matter which might have been offered for that purpose. So what she's saying here, she or he, what they are saying here is what I said earlier in the video. The argument is foreclosed because you never raised the argument in the trial court. So since you never raised it in the trial court, they're going to say you waived that argument. You are collaterally estopped. There's res judicata on this. You can't raise it. Res judicata's verbiage was changed, leaving room for obscurity to take the place of the original verbiage and to derive in the foreclosure or relief after property rights were stripped away from parents. Once you read the new case reference below, think about a bar attorney or the judge, for that matter, acting as counsel for the mother with the fate of its trafficking industry on the line, stating something along the lines that father states that he was deprived of property rights in the former custody proceeding that occurred on 12/12/21, and the support order should be terminated. However, res judicata bars this action because those are claims that could have been raised in the prior court action because custody and child support was an issue. See what I'm saying? Res judicata 1980. Res judicata, a final judgment on the merits of an action, precludes the parties from relitigating issues that were or could have been raised in that action. Now, I need to go and I'm going to study these two definitions a little bit more because this one right here in particular, I kind of don't understand this one a little, and I want to study it some more before I go into a more in-depth analysis on it. Author, as one has read in the original meaning, written in 1876, from which the 1980 Allen meaning derived. The could have raised provision of res judicata doctrine applies to any other admissible matter which might have been offered to defeat the claim or demand in controversy. Oh, okay, I see what he's saying now. Okay, so they're saying you could have raised that argument, but you didn't. You could have raised it, but you didn't. So if you would have raised the argument that since the court has deprived you of the custody of your child, and as a matter of law, by them depriving you of that custody, they also have deprived you of the proceeds to your child's labor, which is a property right. So you could have raised that argument, and if you would have raised that argument would have been sufficient to defeat the mother's claim or whoever of child support, because they deprived you of a property right due to no fault of your own. They deprived you of the services and custody of your child due to no fault of your own. So the equitable thing to do would be to not order you to pay child support, if that makes sense. That's what it seems like that they're saying to me. I'm going to read this one more time. As one has read in the original meaning, written in 1876, from which the 1980 Allen meaning derived, the could have raised provision of res judicata doctrine applies to any other admissible matter which might have been offered to defeat the claim or demand in controversy. Accordingly, the core of the parent's opposing argument is that property rights to the services and labor of his child were not a claim or demand in controversy. See what I'm saying? You should have did it. That's what but they've hidden this stuff though. And proof of such, the only claim or demand in controversy was custody, although your right to property could have been used to defeat any notion of property rights being removed from you, which was not an issue, claim, or demand. It could not be used to defeat any notion of custody in the child's mother. The notion of custody in the child's mother. Imagine the argument today. These rights existed, and you indeed do not deserve the pain, trauma, and wealth transfer that is ongoing. However, because you could have raised those claims after we hid them from you, that you are foreclosed from relief and your claims are now barred. This is what res judicata has set up for. This is what res judicata. Yeah, that's right. That's right. However, no injury is without remedy. This doctrine will not apply if it is to prevent a great injustice. More on this in a few paragraphs, but for now, does res judicata apply anyway? So I think I'm gonna stop right there. Let me see where we at. I'm at 50 minutes. Let me see what the next page is, y'all, and I'll decide if I'm gonna read it. Let me see what the next page is. Give me 1 second. I'm gonna pause the video. All right, y'all. This will be the last page. Page 7 will be the last page, y'all. I guess I'm gonna go ahead and go for an hour, since I'm a little over 50 minutes right now. So this is page 7. If you and the other parent were the only parties in the initial, keyword initial, custody and child support establishment action, then res judicata will not apply to a child support agency or department, because they were not in privity with the mother at the time of the prior action. However, they could allege a privity based on a transfer of assignments that now acts as if the agency was in her shoes at the time of the initial child support hearing. However, an allegation is not a fact. That's right, y'all. An allegation is not a fact. Res judicata cannot go backwards. Moreover, because no immunity can be asserted in an action filed against you by the department with you as the defendant. This is also a reason to use these hearings to then inject your motion to terminate. Otherwise, the department would claim immunity if you filed an action as plaintiff against the department. Before you do so, you need to understand the case laws and how to articulate, or your relief may be foreclosed. Read these case laws and understand and understand. Res judicata does bar relitigation between the former husband and wife. And that is, what is this? I'm not sure which court that was in, but there's the case citation. Anyway, all a father needs to state if the department agency alleges res judicata is that on the date your support order was entered and the date of the action was filed, the department was not in privity with the defendant, therefore res judicata does not apply. Now, the next defense to learn to defeat is collateral estoppel. Collateral estoppel, that's an equitable remedy, just to let y'all know. Collateral estoppel, or issue preclusion, requires 4 elements. The issue sought to be precluded must be the same as that involved in the prior litigation. 2, that issue must have been actually litigated. 3, the issue must have been determined by a final judgment. And 4, the determination must have essential. Let me see. The determination must have essential to the judgment. I'm guessing it must have been essential to the judgment. Collateral estoppel may be asserted by a stranger to the first judgment or decree, but the party against whom it is asserted must have been a party to the earlier action and must have must have had a full and fair opportunity to litigate the issue in the first proceeding. I'm guessing that's another Georgia case. I'm not really sure. Again, similar to res judicata not applying to mother and father proceedings, all a father should state is that the issue of whether you were deprived of value of services through no fault of your own was not a matter in controversy, and proof of such. So you first you make the allegation and then you provide the proof in support of your argument or your allegation. That's what you do. For cases challenging the support order through a motion to terminate in which custody and child support was an issue, in a motion to terminate child support, does the subsequent action arise out of the same transactional nucleus of facts? A bar attorney will most likely, when you defeat res judicata claims that the issue of property rights was matters and claims that could have been raised in the child support proceeding. However, again, only the claim or demand in controversy concerns itself with what could have been raised. In this case, there is an argument to be made that the first case strictly involved the issue of payment for the establishment of child support based on a purported legal obligation, and that the second action involves wholly the determination of that child support order based on issues that the parent was placed on support without fault on his or her part, and a particularized hearing on whether he failed in his moral obligations. This is exactly how it should be worded. The states themselves have failed to make a particularized hearing on this issue, property rights. So the author is essentially telling you what to do. They're telling you how, what argument that you need to use to defeat the child support order. Let's see where we at. About 56. What I'm gonna do, y'all, is I'm not gonna be able to finish that in about 4 minutes. So I'm gonna what I'll do, we'll pick back up on this. I might do another video probably tomorrow or later today. It'll be an hour video. And we'll just go from there. So hopefully this information helps y'all understand this. I'm gonna read this whole entire book. It'll be over the course of, I'll try to do it over the course of a month. It's only 68 pages, so I'll try to do it within a month. And I'll try to do at least an hour. Try to do it at least an hour. So it'll maybe take me about 6 to 8 hours to complete the series. But this is some very good information, y'all. I'd like to thank the reader, not the reader, but the author for this information, and I'd like to thank the author for giving me the permission to make this information public. Again, if you want a copy of this ebook, just go ahead, and post your emails below, or if you already have my email address, go ahead and send me an email, and I'll get back to you with this ebook as soon as I can. I think this is a great start, a very great start with the issue of child support. And hopefully y'all can learn from this and benefit from this. Also, I'm aware that there's probably some people who are already aware of this information. So if you are and you want to add to it, post your comments below and let me know your thoughts, because this is very interesting. Where we at? That will conclude the end of this video. The Supreme Litigant is out. Peace, y'all.